All right, welcome back. So, next chapter is on performance and breach, right? So you can tell we're nearing the end of the course because we look at things in their logical order, right? So first, has a contract been validly formed? Offer, acceptance, consideration, all the requirements that we saw. Then we looked at equity. If a contract has not been formed at law, if you don't meet the legal requirements for one reason or another, can there still be a contract? And equity sometimes, right, again, saves people when they haven't done their homework and hired a lawyer and respected the law, where it would be unfair not to help them. So equity has a set of exceptions that we saw that can make a contract that is illegal, right, that has not been legally formed, valid anyway at equity. Then we looked at, right, contractual interpretation very briefly. So how do you assess what the clause says? Often for the purpose of seeing whether someone has breached it, right? Because you have to see what the clause says before you see whether the conduct of one of the parties respects that clause. Then we looked at defenses to contract enforcement. So someone is suing. Generally, they've shown that there is a breach, right? That one of the parties has not respected the contract. And then the counterparty, right, generally the person being sued, says, no, court can't enforce the contract for one reason or another, unconscionability, duress, right? So basically invalidating a contract that has otherwise been legally, validly formed. It's got offer, acceptance, and consideration, but there's a something else that will nonetheless bar the enforcement of the contract by the courts. Some of them, as we saw, go to contract formation. Sometimes it's a problem when the contract was formed. Someone applied pressure. Someone lied, which is what we call fraud. Statement of fact that is not true. These go back to the time of formation. So although it's a defense, although it's raised later on, in the sense that you've already established offer, acceptance, and consideration, it really means that the contract was never formed, because it goes back to contract formation. Some of them have to do with contract performance, right? They happen later on in the process. And as we saw, for some of them, right, it's only one of the parties that can claim it. So one of the parties can claim that if they've suffered, right, from the harm that's being claimed. And if they don't, the contract's still valid. So not everything voids the contract. Sometimes the contract can still be confirmed by one of the parties. Then we look at, right, chapter is on performance and breach, or just to backtrack a little bit, right, as I said earlier, to defend my choice of textbooks, right, the chapter on the defenses to contract enforcement is called protection of weaker parties, and that's because they all generally have to do with that broadly. They have to do with preserving the fairness of the process when something hasn't been fair to one of the parties, when there's an imbalance of bargaining power, of disclosure, of money, of having a lawyer. It's not, right, it's not a mirror image between the parties, and so the courts, right, might step in to try to remediate that, generally when it has an actual consequence, when the resulting contract is not fair. Then we looked at public policy, which is another exception to contract enforcement, right? It's broad, but really we see most of the actual ways in which it's applied. So after that, right, we kind of recapped all the course so far. Of course, you look at performance, right, which generally will be pretty straightforward. There's a clause, you see what it says, and then the conduct is claimed to fall within that. Breach is non-performance. Breach is when you do not respect the clause. And then ultimately, right, next chapter is going to be on damages. So how do we count how much money you get when we have found that you have not respected your contract? We'll look at remedies specifically. We said that generally by default the contractual remedy is money. It's not what we call specific performance. It's not forcing you to do what you didn't do under the contract. So bring the apples, for example, It is to give you money, and that money, as we said, as we'll see in a lot more detail, is assessed based on what we call the benefit of the bargain, which is what position would you have been in. So say you want to sell a car, sale doesn't happen in breach of the contract, the benefit would be the profit, the money you would have made. Okay, so we're looking at breach here. And we'll look at what are called conditions precedent, we'll look at what's called repudiatory breach, and then we'll look at what's called the duty to perform obligations in good faith, which is something that the Supreme Court of Canada made up several years ago in advancing an incremental but pretty significant step to the evolution of the common law by realizing that, right, there were obligations that looked a lot like good faith, right, in various stages or permutations of the contract formation and performance process. And so the court said, right, it's not a big step now to say there's a general obligation to perform your contract in good faith, which generally means not to lie, but we'll see it's slightly broader than that. So the specific issue that we mostly look at today has to do with further performance, and that's where I want to be careful. There will be, in almost all of these cases, a party that has breached a contract. They have not respected the contract. Everything we see here today is about what the other party can and cannot do. It's not about the breach. So it's important to remember in all of these cases that we'll cover, there is still a breach. That means the party hasn't respected, the counterparty will get money, or whatever other remedy they can claim, generally money, as we said, right? That's still true. We're just looking at what the counterparty can do. So do they have to keep performing under the contract? So say it's delivery of apples. Do they have to keep taking the new apples if some apples are bad or don't respect the contract? Or can they just stop and go hire someone else? Is their mutual obligation, their future obligation, excused or not? Sell a car, right? That's one thing that doesn't happen over time. Same thing, right? They don't get the money. Are they obliged to, right, give the car? Of course, the answer is going to be no. That's what we look at. We look at whether the counterparty is it also excused from performance. And generally that will turn on the intention of the parties, and it will turn on how big the breach is. Not that that's a criterion in itself anymore, but really how much the breach, how the significance of it goes to the root, the main thing in the contract or not. Again, that has nothing to do with the first breach. The first party that breached a contract, regardless of what the counterparty gets to be excused from, is still in breach. That means that the counterparty will still get money. Regardless of whether they have to deliver the car or not, take the future apples or not, they still get money for the initial breach because that's a breach of contract. We just don't cover it here because damages goes after breach, and that's in the next chapter. As we'll see, we can waive a condition. We can waive a breach as it applies to future performance. So, still a breach, still get you money. But the contract might say, whatever the breach is, it's going to cancel the entire contract, right? Maybe it's a trust relationship. You really like your Apple supplier, and you can't imagine working with someone that would just once decide to send you non-compliant apples. And so you say in the contract, if once there's a shipment of non-compliant samples, it's going to cancel our entire multi-year contract. You can say that. Okay? The extent you have that, it's going to say that. These kinds of conditions, as we'll see, can be waived. So that means if the clause is triggered, so it applies, right? You're excused. Not always true, but now your contract says that, so it's true this time, right? Contract allows you to do that. You can not exercise that right and then be thought to have waived it. So if you don't exercise it in time, as we'll see, you can't exercise it at all. That's what waiver of the clause means. Okay. So 673 and following, there's a discussion of repudiatory breach, right? So basically, when can you assume that further performance is excused, that it doesn't have to happen because of the initial breach. You have a number of cases, right, which reiterate many of the same principles. 674, first case, you have so the Kingston case, you have discussion of the various kinds of what they call covenants. Basically, right, reiterates what I said. They say there's 3 types of contracts, right? Really, you might say there are 2, but right, there are contracts where the performance of an obligation does not depend on the performance of another obligation, right? So what one party has to do isn't that closely related to what the other party has to do, such that, again, breach is still breach, they will only get money. They won't get to cancel the contract. Sometimes they're too closely related, such that they're going to cancel each other. So sell the car, right? You don't get the money, you don't have to give the car. They're directly related. The reason why you would have given the car is because you would have gotten the money. Most of them are, right, kind of intermediate situations where it's not actually clear which one it is. And then it's going to depend on common sense factors, like how serious is the breach? And generally that means, does it go to the root of the contract, the main thing of the contract, such that the counterparty is what we'd say frustrated, right? So they are not getting the whole reason why they contracted for in the first place, and so they should be excused from performance. Okay, 674, right? McDonald case obviously is like 4 sentences there, but tells you that the parties can always modify the common law by agreement, because again, contract law is all about intent, agreement, and respecting the intention of the parties. So, if you say in your contract that any breach, as in my examples, right? You really like your Apple supplier. So, any breach will cancel the whole contract. The common law would not say that, right? It would say you entered into a 3-year contract for apples. It's the one time, right? They're bad. Clearly, it's not the root of the contract, because it's a multi-year contract. You get apples every week. It's just once, right? Shouldn't let you get out of the contract. And again, if you do, it would kind of suggest that you're doing that for ulterior motives, right? So here, parties can modify that by contract, always true. So if your contract says any breach will cancel it, then the courts will respect that. 675 and following, right? Bettini case, there's 2 cases about opera singers or performers, right? There's a contract, she'll be the main performer for the show. In both cases, the person ends up getting sick. Okay, in both cases, there's an issue as to excuse, right, as to whether or not they'll owe money for having been sick because it's not their fault, right? So strictly they're in breach of the contract. Contract says you have to show up on that date, right? You don't show up, you're in breach of the clause. Doesn't matter why, right? Doesn't matter because it's a good reason you were sick, you could not physically be there, okay? So that's whether performance is excused. We'll see that later on. It's pretty narrow, so most situations they would still be in breach, therefore owe money. Again, we're not concerned about money, the breach. We're concerned about what the counterparty can do. So, SIG doesn't show up. Is that sufficiently serious or important for the whole contract to be canceled? For the correlative performance to be excused? In other words, right, can they hire someone else permanently, not just temporarily as they wait for the performer to get better? Okay. Court engages in a contextual assessment, right? So as I said, always depends on the circumstances, based on pretty obvious factors. So how long is she going to be sick for? To what extent can you secure a temporary replacement, right? So it might be an industry where you cannot find short-term labor, so no one's going to sign a contract with you unless it's a permanent contract. So then, right, might be sick for a shorter period of time. It'll still be reasonable for you to cancel the contract and hire someone else because it's the only option that you have. How serious it is for the parties, right? It's serious because she ruins the whole show. The show is about her. Okay, there are issues of contractual interpretation. So you look at, right, the entirety of the contract, the surrounding circumstances to assess how serious it is and whether it goes to the root of the contract. So these principles, right, the root of the contract and all of that are mentioned at 676. You always start with the contract itself, right? So the words, their meaning as within the contract before you get into surrounding circumstances. You'll recall we saw that pretty directly under the parole evidence rule, which had, right, negotiations surrounding circumstances are not relevant, in fact, are inadmissible into evidence or forbidden from coming to court unless the contract in itself is unclear. So unless you need to use that evidence to figure out what the words are trying to say. In that case, right, it's an exclusive contract and it's for a long period of time. So you'd expect, right, the person to be sick for a relatively longer period of time if the contract is for multi-year contract, right? Same as my Apple's example, and also if it's an exclusive contract in that example, right? So in that case, it's a multi-year contract and it's exclusive. So singer can't offer their services to someone else. Therefore, it's not likely that being sick for a short period of time will go to the root of the contract. That's why in that case the singer wins. Okay, Poussard case, page 677. Basically same set of facts. Goes the opposite way because of, again, the specific circumstances. So she's hired for a specific show. She's sick for a relatively long period of time. And there is an indication that, as I suggested earlier, you can't get short-term labor. So even if the concert hall people wanted to hire someone else for only a limited period of time, they can't find someone. So it makes it reasonable for them to hire a permanent substitute after a shorter period of time, which is a different way to say that being sick is going to go to the root of the contract and therefore allow for, right, the whole contract to be canceled, for the counterparty, the concert hall, not to have to perform, which means, right, not have to pay her to perform when she's no longer sick. They can hire someone else instead. They can cancel the contract, replace it with a new one, a new contract that has a different performer, right, be the star of the show. Okay. It's a factual set of assessment, as I suggested, that's reiterated again at 679, whether it goes to the root of the contract. You look at the context, which generally means, right, what the parties were trying to contract for. So what was their main objective, their main purpose, and is that frustrated? If it is, it's likely that the counterparty will be excused in the event of a breach. 680, you have a case from Lord Denning. It had been a while, right? So often surprising legal principles, but at least he writes in a way that's very accessible for his time. So you have a contract for a byproduct of oranges. The facts don't really matter all that much, right? But byproduct of oranges, there's a breach, right? So there's one of the shipments, so it's a multi-year contract, lots of shipments, like my Apple's example, right? One of the shipments is not compliant. You're told it's actually not compliant. And then the question is whether there can be, right, repudiatory breach. So whether the counterparty can decline further shipments. So it can say, I don't want you to be my supplier anymore at all. Not just a one time, because of course the one time there's a breach. So there's compensation for that. But later on, right, further performance, can you excuse that? Do you have to keep taking on the new apples even if they are compliant? Interestingly, again there, 680, you have an example of the intent of the parties being respected. So there's a clause in the contract that says each shipment shall be considered a separate contract. That's the opposite of the example I gave earlier. You can have your contract say any breach will allow us to cancel the whole contract. And then, as I said, the courts will respect that. That's the opposite. Saying each shipment will be a separate contract is saying if there's a breach in a shipment, it's only a breach of the one contract. So you won't have to pay for the oranges. You won't be able to cancel your obligation to get future shipments precisely because they are separate contracts. So that's another way to evidence an intent of the parties, the opposite one, and the courts will respect that, right? They'll generally apply that. So there's a lot of complex facts, right? Basically, there's a non-compliant shipment, and then there's this big drama where no one takes it, right? So the purchaser, the buyer says, I don't want them, they're not compliant. And then the seller says, you have to take them, they're not compliant, right? And no one takes them, they're just abandoned, and then some guy shows up, and then that guy ends up reselling them, right? The only relevance of that is he resells them for a lot of money, which suggests they were pretty compliant, right? Because they were sold for their intended purpose. What that drama does show you, though, is a factual situation that we see in all or most of these cases. And that is, there's no way to know, right? So that's a corollary of saying the test is you see the circumstances. You see whether it's the root of the contract, whether it's really important or not, whether the parties intended for that to be important or not, in assessing whether the counterparty can be excused, whether the breach by one party cancels the whole contract or not. Saying it's factual is the same thing as saying you can't know until a court tells you, right? You can tell how you'd assess a specific set of circumstances, but you can't get a definite legal answer. It's not like when the statute says your contract is not valid, right? It depends. And so in these cases, when you're the party who's, right, experiencing the breach, when the counterparty doesn't perform, you have no way to know, really, whether you can cancel the whole contract or not. Again, unless your contract says that, right? And so you have to take a legal position, which might turn out to be incorrect. And that's why you end up with situations like that, with neither of the party taking it, right? Taking the oranges. That's because they have conflicting interpretations. One of them has hired a lawyer, right? In fact, they have actually hired a lawyer and gotten incorrect advice. It's mentioned at the end of the case, right? One of them hires a lawyer. Lawyer says, you can cancel the whole contract. Other one says, no. And then the parties adopt conflicting position, and you don't really have to know a way to know which is correct in a definitive way until a court has ruled on the issue, because it's that, right? It's always fact sensitive. Okay. As a general rule, right, there's a discussion of a condition or a warranty. A warranty is something you can sue on. So if it says, right, I'm selling you goods, they have to be fit for a specific purpose. In fact, you have a statute that's cited at page 682 called Sales of Goods Act, right? There's lots of statutes like that regulate sales of goods, right? So sales of generally stuff, generally from sophisticated, wealthy commercial parties to unsophisticated, not wealthy, not commercial parties. Normal people without a lawyer, without a lot of money, right? And there's a general warranty. We saw that earlier in the course, right? That says goods are going to be fit for their intended purpose. So you can't sell something that doesn't perform as advertised. If you say it's going to do something, it's got to do that. Otherwise, you can get sued. Warranty and condition, same discussion we had. Warranty is you say that. If it ain't true, you can sue. If it's really bad, you can rescind the contract. Condition is something that has to be respected, which is saying if it's not respected, it cancels the whole contract. It's saying, right, goes to the root of the contract or not. Okay, there's another issue that we don't cover, which is called anticipatory breach. You have that at page 683. So different from repudiatory breach. So when the counterparty doesn't perform, then you're trying to figure out whether you have to perform or not. Whether, again, you can cancel the whole contract or not. That's repudiatory breach. Anticipatory breach is something else we don't really cover, which is when a party says they won't perform. So sometimes you can rescind the contract, cancel the whole contract before anything's ever actually happened. So one of the parties can say, I do not intend to perform the contract. And then you call your lawyer, right, calls them up, shouts at them, and then they are still out of their mind and decide that they will not perform the contract. You can, in some circumstances that we won't directly cover, decide that you deem the contract to have been repudiated. You deem that the counterparty is out of their mind, won't change their mind, and so you can assume that they won't perform, and you can decide not to perform yourself, right, to be excused before anything is actually happened. It's only words, right, not actions in breach of the contract yet. Okay. 684 reiterates what I said earlier. Most stipulations are what they called intermediate stipulations. So if the contract says you can cancel the whole contract, which is a condition, you can. If the contract says you can never do that, or if it says each transaction is severable, it is. Most contracts don't say that, right? They're what they call intermediate stipulations, and then it depends. The test, right, the contextual test applies. You have to see how serious the breach is, does it go to the root, and then that determines whether or not the counterparty is allowed not to perform their part of the contract. In that case, it's what they call an intermediate stipulation because it's a multi-year contract. Because what they call small portion, 685, of the cargo is bad, so not that many orange pellets are bad, it cannot allow for the entire contract to be canceled. It cannot justify the counterparty repudiating the entirety of the contract. So what that means, again, because it never excludes the breach and the money, they still get to sue for money because of the breach. But they have to keep performing. They can't, on top of getting money, deem that the entire contract is canceled and that they themselves will not have to perform their part of the contract. What they call the commercial man standard 686 is the same thing, right? In these circumstances, in that industry, between these kinds of parties, would a person normally assume that you can cancel the whole contract? Would they normally assume that it goes to the root of the contract, that it's the very thing that you contracted for, such that you can treat the contract as having been repudiated when there's a breach? 687 reiterates what I said, right? When it doesn't respect that, oftentimes it means that people are doing things for strategical reasons, right? So they don't want to respect the contract for another reason, and then they come up with that doctrine because it can serve their purpose, and when that's the case, courts are reluctant to allow that. Sale of Goods Act, page 688, reiterates the standard, which is you look at the circumstances of the case. So it depends, what they call, quote, in each case, right? That's what the Sale of Goods Act says. Okay, Maple Flug case, page 688. Again, you have a shipment. It's not compliant per a government standard, right? So, same thing there, right? The government standard doesn't invalidate the contract. It doesn't say if you ship stuff that doesn't respect the government standard, your contract is invalid. If it did, right, that's not even public policy or anything related. It's just the statute. Statute invalidates your contract. Statute's always right. Statute prevails. Your contract's not valid. So, not what happens there, right? It's not compliant. Statute says it's got to be compliant, but it doesn't say your contract is invalid, right? Your transportation contract is invalid. Looks at the circumstances, same thing. If it's a multi-year contract, it's not likely that the 1 week it's not compliant will allow you to cancel the whole contract. So court says that as well if it's not a significant breach, right? So either if, right, one shipment is not compliant out of many, or if it's not compliant, which is the case there, and the parties have a good history of compliance. They always ship compliant stuff except the one time. That suggests that it's a mistake, and therefore that, right, they did not intend for that to allow for, right, further deliveries to be excused. So it's what they would call an intermediate stipulation again, right? Because the contract doesn't explicitly say whether you're fully excused from performance or not. So you have to look at the circumstances to assess whether, right, what was the intention of the parties and what the intention of similarly situated parties in a similar situation would be. 90 and 91 reiterates, right, all the principles we said. Does it go to the root of the contract? Another way to put that is what they call, quote, the whole object of the contract is frustrated, end quote. Okay, and if again, because the shipment is not compliant, then, right, cannot be used to engage in a repudiatory breach. 691, you have the restatement of contracts, which is pretty interesting, right? As we said, the restatement is not, first, it's not a statute, and it's not supposed to create really law, right? There's a lot of disagreement as to whether it does that or not, right? It's a philosophical disagreement, but really you can't ever state the law in a way that doesn't kind of change it, right? Because it's not how cases work. Cases never say, this is the principle, right? The ratio. It never really exists. It says, in these circumstances, we decide this way, right? And then it says these other circumstances are similar enough or different enough so that it does or does not apply. So, at some point, someone says, right, all the cases where there's this criterion, there's this characteristic, are decided the same way. There's a rule, right? Stating the rule is never in the case, right? So you're always moving the law somewhat. Nonetheless, right, except in that narrow sense, the restatement of contracts is not supposed to change the law. It's supposed to state the law. So it's supposed to do what I just did, right? Look at the various cases and try to see whether a rule has emerged. So whatever you see as the set of things you can use to assess whether or not there can be a repudiatory breach, these are, at least to the people who wrote the restatement of contracts, simply a summary of the case law. Doesn't advance it in any way. Doesn't change it in any way. So, interesting ones, right? 681, whether the party, the counterparty, so one breaches, whether the other one will be deprived of the benefit they would reasonably expect under the contract. That means the root, the object of the contract. Whether they can be adequately compensated. So whether giving them money is going to fix the problem and allow them to go on with performance, right? Allow the relationship between the parties to keep going on, and the money will fix the problem. If that's the case, not likely that it goes to the root of the contract, and whether, right, there are steps taken to cure the problem or steps that can be taken to cure the problem. These are, again, contextual factors to see whether your specific set of circumstances allows for the counterparty to be excused when there's a breach, or the whole contract to be canceled is how I put it. Okay, 692, we start another section on waivers and conditions precedent, very similar to what we described earlier. What they called a condition is when you can decide not to perform. So when there's a condition, right, when there's just something that is we'll take it the other way. When an event has to happen for the counterparty to have to perform, generally it excuses the thing. The event doesn't happen, right? It's excused. Sometimes you have a condition, what they call precedent to the formation of the contract. So sometimes it's going to say our contract is not valid unless something happens. And when it's not within the control of the parties, then the contract's not going to be valid unless that condition is met, and it's precedent because it's before. It has to be met before the contract is valid. So you have an example there. There's the Pnutsos case. There is a contract for the sale of flour, and then there's a condition in the contract that says for the shipments to happen or to be valid, you got to have like a line of credit or something like that, right? And a firm commitment from the bank. So not a line of credit that's conditional on, say, right, getting the flour. And then there's a shipment. Turns out that the line of credit was not compliant. Counterparty is now aware of that, and they say, right, you didn't respect the contract. And they try not only, again, to sue for damages, which you always can do in this chapter, right? They also try to be excused from performing their part of the contract. So they try to, again, quote unquote, cancel the whole contract. And the main issue that arises in that case is about waiver, right? So if you want to see whether it excuses performance, again, you look at the root of the contract. I won't repeat that, right, the 20th time. There is an issue as to waiver, though. So in that case, it's clearly one of the parties that benefits, right? So one of them has to have a line of credit. Clearly, they won't be the one claiming they don't have the line of credit because it's not to their advantage. They won't try to cancel their own contract and therefore not get paid, right? So it's to the benefit of the counterparty, and the counterparty can waive that. So even if they had a right to have a repudiatory breach, even if it was such a serious condition that if it's not met, they don't have to perform, they can waive that. They can choose to still perform. They can say, I don't really care about the line of credit. I'm going to send the flour anyway, which is precisely what they did. And when they do that, they can later on claim it, which again is a different way to say later on if they're claiming it, it's for strategic ulterior motives, and the courts don't like that, don't try to condone that. So they try to claim that later on. The counterparty can claim waiver. They can claim that they had a right, but they waived it, and they cannot exercise it. A different way to say that is estoppel. We covered that under equity, under contract formation, right? So when your contract is invalidly formed, no offer, acceptance, or consideration, you can have an equity exception that enforces a contract. Estoppel is at equity. It's when you can't claim a right, right? So, for example, to contract invalidity, there's no consideration. So it's a contract for donation to university, for example. Not valid, no consideration. You still give the money to the university. Then you can't claim the contract wasn't valid. You're stopped from doing that. So you had a right, you didn't exercise it, you can no longer exercise it, generally because it would be unfair. Same thing there with waiver. You had a contractual right to say there's no line of credit. You didn't exercise that in time, and so you waived it. Now you have to pay for the flour, right? When you get the flour that you asked for because you didn't care about the line of credit, which was a condition precedent to them sending the flour, then you can't later on try to not pay for the flour that you asked for and got by trying to rely on the line of credit. The discussion of reasonable notice at page 693 is the same thing. You have to know, right? So they have to call you up and say, we repudiate the contract. We consider that this breach is so bad that we cannot perform our part of the contract. Otherwise, the counterparty is not going to know. They're going to send the flour. They're going to pay the money. And it's going to be unfair. So same thing as estoppel. If you don't complain about it, right, loudly enough, you will be stopped from claiming it. You won't have exercised your right, and so you'll be prevented from, right, exercising it in the future because the counterparty has to know so that they don't perform. They have to know you're repudiating so that they choose not to perform their part of the contract, so that they treat the contract as indeed having been repudiated and respect that. 695, there's a short case that has to do with, again, a condition precedent to the formation of a contract. So they sign a contract for the sale of land, and it says basically the city's got to approve something, right? So we're selling it because we want to convert the land to build something on it, basically, right? And then eventually, it's not approved. City does not approve it. There's a claim for specific performance. So land is one example where you don't get damages, where you don't get money, you get the thing itself. So land you can get specific performance for. So someone claims the land, and the counterparty says no, because that was contingent on us getting our city approval we were trying to get. And to the extent that that's the case, where it's mutual, it's precedent, and it's out of their control, which is a different way to put the first two criteria, then the contract was never formed because there was a condition precedent, a condition that had to be met before the contract happened. Condition was not met, so the contract was never formed. And that's it for today.